Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we are giving all our focus on section 3, which is interpretation clause. This is a very important section because only when we understand the terms here, we can understand the law easily. In one of my previous lecture, we have already discussed about fact, and here I am going to discuss about the status of fact. Now, facts can either be proved or disproved or not proved. I am going to discuss about all of them in this sixth video on the series of interpretation clause. Why to waste time? Let's get into the only slide. As I have already told in the introduction, there are three types or three status of facts. The first one, which is proved facts. The second one, the disproved facts. And the third one is not proved facts. Let's start the discussion by understanding the term proved or the status of facts as proved. The legal language here is very easy, which says a fact is said to be proved when, after considering the matter before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. To make it simpler, when an issue comes in front of the court sees all the matters available in front of it, and after seeing all the matters, it believes or considers that such fact is existing. And any given day, if the same circumstances is given to a prudent man ought, he will also probably says that yes, it is a fact. In that case, those are called as proved facts. Now, court may not be able to make 100% decision. That is why the term probable is used there. And probability with whom? Probability with a prudent man ought, under the circumstances of the particular case, to act upon the supposition of that it exists. And if he is also going to say that yes, it is a fact, then court is going to say yes, it is a fact, and those are the proved facts. Now, of course, no court is going to ask a prudent man's opinion, but you need to understand the legal language. That is very important here. The second status of facts is disproved. Now that we know what is proved, when court gets an issue and it considers all the matters which are involved in that particular issue, and after seeing everything, it either believes that it does not exist or it considers its non-existence. And as I have already told, if the opportunity is given to a prudent man ought with the similar circumstances of a particular case, he will also say that yes, such things or such issue is not existing or such facts are not existing. In that case, those are disproved facts. The legal language on disproved says a fact is said to be disproved when, after considering the matter before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. Now, that is all about disproved. The last one is not proved. We have two status already. One proved, the other one disproved. Now, something may not end just like that. The court may have further questions. Here, we cannot say it as either proved or as disproved. When a particular fact is neither proved nor disproved, we are calling them as not proved. One case law that you can refer here is State of West Bengal versus Station Orilal Jaiswal. Here, Supreme Court observed that proof does not mean rigid mathematical demonstration because that is impossible. That is why you can see probability in both proved and disproved definition. Now it means such evidence as would induce a reasonable man to come to a conclusion. That is what we are believing with the word probable. So that is the importance which is discussed in this particular case law, and this is not the end on the discussion of facts. We are further going to discuss on facts in chapter 2 where the relevancy of facts are discussed, and then in chapter 4 we are discussing oral evidence. Chapter 5 are also on facts where we are discussing about documentary evidence, and in chapter 7 again we are discussing about facts where we are discussing the burden of proof. That is the end of 6th video on interpretation clause. The 7th and mostly the last one is coming up in my next video, that is on the term evidence, which is going to be very important, and I am preparing the material on the same. See you with that in my next class. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.